two applications scheduled for this morning. One is the stay of proceedings. In view of the fact that both are scheduled for today, and the review will be taken today, I crave your indulgence to withdraw the application for stay of proceedings. Oh, yeah.
The extension of time. It should also be before the ordinary bench. So that was why we decided that we can take. The lead counsel is now in. Yes.
Very well.
You can take the review.
So Mr. Chikata will take the review.
My Lords, respectfully, we have an application for review before your Lordships.
Time management, you have 30 minutes.
Very well.
And there will be no extension of time.
I'm sorry, I didn't hear that.
There will be no extension of time.
The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And this review is in respect of our application to reopen our case. And your Lordship's ruling is our first exhibit attached to the application. And in our respectful submission, as our ground A indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your Lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your Lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my Lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Reports 140, where their Lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it account. They had failed to take it into account. And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that once there is no reference to a statute which is binding on your lordships, we do not need to show further that there is a miscarriage of justice. The failure to apply a statute of the law of Ghana is enough of a miscarriage of justice in accordance with the decision Republic and Tete. And if non-compliance with a statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action a party or a person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson of the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black's Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The rules of court committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the Rules of Court Committee, that is fundamental.
Mr.
error.
Chikata,
Yes.
are you suggesting that CIs do not go to Parliament?
CIs go to Parliament, but they go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission, who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My Lord, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule...
Isn't that the exercise of our discretion which prefaces the section that you read?
My Lord, it's that those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear. And unless the ruling is being rewritten, the terms are very clear. Namely that the evidence section 20, we wish to state that, this is at page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38, Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more, nothing less.
Mr. Chikata,
Yes.
do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except my reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with the application of the Evidence Act, Section 26. Order 38, 3E5. It reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption. based on the estoppel by own statement in section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say, one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands